The 36th District Court in the state of Michigan is now in session with the Honorable Donald Coleman presiding. While court is in session, there'll be no talking, sleeping, chewing of gum, or reading any materials, and please no driving.
All right, this is case number 21-149963. This is Michigan First Credit Union versus Nicole Willis. Matters before the court set on for review regarding an installment order. Do I have counsel for Michigan First, please?
Yes, Your Honor. Good morning. Michael T. Mamet, P811002 on behalf of plaintiff.
All right, thank you, counsel. Do I have Nicole Willis here or anybody representing Ms. Willis? Say something if you're here.
Good morning. This is Nicole Willis.
All right, Ms. Willis, good morning to you, ma'am. This is, of course, the update on this matter. Counsel, you go first and update me regarding this matter, please.
Your Honor, on January 11th, this court ordered installment payments for $125 a month. At the time, the defendant claimed to be unemployed, so we kept the payment where it was. We scheduled this date to review to see if she had found employment, if we can increase the payments.
All right, and Ms. Willis, go ahead and talk to me. I do recall setting it up in that manner. I know that the judgment in this matter looked like it was in the nature of approximately $7,000, and I had you working at General Motors. Go ahead and talk to me, ma'am.
Good morning. I'm back to work. I'm currently back to work, but I don't think I'll be able to increase.
All right, so when you say you're not able to increase, why would you not be able to increase given that you were paying $125 before you went back to full employment? Go ahead and talk to me.
Good. I can submit like all my bills. I really don't see it at all. Like if I had to pay more, I wouldn't be able to pay my bills here at the house.
All right, counsel.
Your Honor, I believe I'm in the same boat as the court. I don't understand how $125 with zero income was feasible, but now being back to work, increasing that amount would not be feasible, especially if we look at her affidavit. I'm curious as to how she was paying $3,500 in bills over the last 6 months with no income. And then if she got, or when she got full-time employment, is now unable to fulfill the obligation to my client in the court. I would like to see proof of income, proof of expenses.
All right.
I sure can submit that.
All right, so ma'am, here's the challenge. The challenge is that if the court allows a wage assignment, wage garnishment in this case, that's going to be 25% of what your take home would be, and and if you get paid weekly, it'll be 25% weekly or whichever schedule you get paid on. And it seems to me that if that garnishment is in place, that's probably going to hit you for like, I'm calculating that you're going to be in the nature of $1,000 to $1,200 a month with the court order garnishment. We're on the same page here.
Yes.
So here's what I'm getting at. I mean,
okay.
You don't have a $20,000 judgment, whatever it is. Counsel, you have a balance on this at this point?
Yes, Your Honor. This morning, the balance is $5,602.91. I will let the court know that the defendant has made, it looks like every $125 payment, except for this month. I don't believe we've received it or processed it yet. It could be in our mailbox this morning. So, I mean, my fear is I think the defendant is worried that I'm going to ask to increase this to like $500 a month or something. I'm not looking to do that, especially because she's made those payments. I mean, if we can get even in the ballpark at $200 a month, that I'd be more than happy at this point. I'm not trying to put her in a pinch or, take every extra penny she's got.
And the other,
now, thank you.
Before you talk, Ms. Willis, the other issue here is that you have a balance of $5,600. This is not a $10,000 balance now. The ideal here is to try it, see if a little bit more can move this closer to trying to get it ultimately resolved. So I would not be inclined to put anything up like $500 or whatever. I was just saying that if you got a situation where there's garnishment, I mean, it's probably $1,200 a month or somewhere in the neighborhood. I do think that somewhere between, here's where my thoughts are, somewhere between 125 and $250 is what I was thinking. If you can do $200 a month, that seems like a good number, and that only raises it by $75, and then you all said you don't have to come back. Just be faithful to it like you've been up to now. You're paying the 125. If you're paying the $200 a month, I don't think you're gonna have any problem here. You get this paid off. It's still gonna take a little while, but then when you're done, you're done.
Okay. Well, can you up it to the 200? I'm able to do the 200, but I was thinking more like 500-700, and I'm like, how will I be able to pay my household bill if he went that high?
No, and it's up to the court to ultimately make that decision. But no, this is not the kind of case that the court would be looking to set that high number. One is because you've been paying the amount that was set, and then secondly, because the judgment is less than $6,000. Sometimes I have to make the payment higher because you owe $15,000. But fortunately, you don't owe that amount, and so we don't have to set the that high to do that. So I'll amend the payment to $200 a month. And if you haven't paid the June payment, go ahead and make sure you take that. The $200 would commence in July. So the June payment is still $125. In July, you will be getting $200 per month.
Okay, so I have a question because you set it for June 30th. Can we keep the payment at that 30th date?
Yeah, if that's when it's due, right? So
Okay.
you pay June 30th
Mm-hmm.
and pay the 200 on 30th of July.
Okay.
Right.
Then,
All right.
then, Your Honor, I might have been mistaken. We might be waiting on May's payment. I apologize for that. Not June's payment. We might be waiting on May's payment. If it was due on the 30th.
May,
but
yes, and it should be there.
All right, excellent. And then will the court be sending out the order, or would the court want me to submit one?
Yeah, I'll go ahead and do an amended. I'll do an amended order reflecting what the court has determined today. All right. So I will also.
Excellent. Thank you very much, Your Honor. Have a great day.
Thank you. Good day.
Thank you, man. All right, the court now calls case number 23-149-193. This is Melvin Houston versus Avis Budget Car Rental LLC. The matter is before the court, settling for a hearing on a motion for summary disposition. Your appearance for plaintiff in this matter, please.
Good morning, Your Honor. May it please this honorable court and your staff. Melvin Houston, P number 36280.
All right, thank you, Mr. Houston. Counsel, good morning to you, sir. For Avis Budget Rental Car, please.
Good morning, Judge. Chad Dushinsky on behalf of defendant Avis, P number 81872.
Thank you, Mr. Dushinsky, and good morning to you as well, sir. Defendant's motion for summary disposition and response to the same. Any preliminary issues at this time? Have you all talked about this, or you simply want to go forward with the motion?
Your Honor, I had the opportunity, and we actually resolved this matter. We are just exchanging some closing documents, so we wanted to appear today because we haven't presented those to the court yet. So.
Yeah, I can't get any better than this, Judge. You thought you read all that stuff for nothing, huh?
That's, I guess it makes me feel like, well, do your job one way or the other. All right, well, that's a good thing. And it's always good to see when lawyers have work for me to get this worked out.
It shouldn't take too long.
Days we should be able to submit an order as to dismissal. Yeah.
All right.
Yeah, I agree, Your Honor. We've been cooperating pretty well.
Sounds good. So I'm going to go for the, just 1 second. For the 30th of June. So June 30th. And I'll take a look at a new court date. That's just a day for me to review it on June 30th. And I'll be looking for documents by then.
Okay,
All
understood.
right,
Thank you.
sounds good, Your Honor.
All right, good day to both of you.
All right, do the same. Stay safe, everyone.
You too.
All right.
Okay.
Thank you.
All right, do I have well, this is Lynn Chiropractic PC versus City of Detroit and Suburban Mobility Transportation Authority. Either party present on that matter. We'll recall that matter. And either of the council that are on the Zoom, are you do you have any other matter in front of me at this time?
Yes, Your Honor. I have Genesis Credit Union and Tevin McCulkey, something like that.
I have the Genesis case, and that's set for 10 o'clock, so I know why you're waiting here. Give it a few more minutes. You had, what's the other one that you have?
Oh, no, the Genesis was my last one this morning, Your Honor.
Gotcha. Yeah, it's separate 10. I have it for 10, and so we'll just pass 10 and then I'll recall.
It's been filed where I just don't know if it's on your desk yet. So, I mean, the objection would be moot at this point, whether or not the defendant's here. It's paid. I'm done with it. We can wait though. I got no problem waiting for the defendant just so everything was.
This is case number 18-176-115. This is Genesis Credit Union versus Tevin Kelly. That's MCKELDY. Looks like the matter is before the court set on for a hearing on objections to a writ of garnishment regarding a judgment that was entered in this case on the 22nd of March of 2019 for $7,278.34. And this is set for 10 a.m. Counsel, off the record, did give the court some information. Counsel, your appearance on this matter, sir.
Your Honor, Michael T. Mamet, P81102 on behalf of plaintiff.
Thank you, counsel. And I know the other party, they're probably, if they're going to come in, you've indicated something to me off the record that a satisfaction of judgment has been submitted. The objections to the writ of garnishment, it seems that you would indicate that the objections would be valid at this point. Go ahead, tell me where you are regarding this matter.
Yes, Your Honor. Your Honor, the defendant has paid the judgment in full, including cost, fees, and interest. We received the last payment on May 31. Our satisfaction of judgment was filed with the court 6/7. I don't know if it's just not gotten to your chambers yet or the bench or anything, but at this time, I believe that the objection to garnishment could be denied as moot, and our wage garn release and I believe a tax garn release were both filed at the end of May as well. I don't know if the court has either or both of those.
And the file does not show filing of any releases or that they have made their way to the file yet. Let me look at one thing. Can we get a register of action on this? 18,179,115.
And if the court would be more comfortable, I can have all that documentation emailed directly to your clerk at some.
That would be great. Let me look at the register of action and see if somebody who received it might have noted it. Yeah, I don't have, the register of action is not showing that any of that has been inputted, so it's likely somewhere around, but it certainly has not been documented on our end. So you would email stuff to her, to Ms. Hunter. I think you have her email address, correct?
I do not on me. Would she be able to type it into the chat for me?
Yes. Are you still on?
Mm-mm.
Well, I'll put it in there and get it to you.
Thank you, Your Honor.
And just hold tight for a minute. We're close enough to that time. We'll see if the other side.
Oh, yeah, no problem, Your Honor. I'd rather be safe than sorry with a,
Yeah. I thought it might have been a little more simple than what it is. So
I mean, the satisfaction was just sent to the court on the 7th, so I'm not surprised that it hasn't made its way upstairs. It might not even be at the court yet if we mailed it, so I'm not stressing out.
yeah. See, but does it matter whether that first, whether the L is capital or not?
No, no.
That's on another case.
Mhm.
On Zoom. We'll be calling your matter shortly, Mr. Carter. Just sit back. Do we have any other order for installment?
just the new ones. I got you a new one.
This is some packets.
Yeah, those are the new ones. I went downstairs and got it right here. Order the motion and stuff. Set aside, here, set aside. Set aside. Those are the new, this should be the new ones. Those I just put down. All right. Or for those objection terms.
Yeah, those objection terms. All these are ordered.
Yeah, okay, yes, I got this. Yeah, she put, she looked at this today, where it's set aside, solid paint, so we have to, we don't need these, right?
Yeah, we don't really.
Okay, I get it.
You
So you want-
have some of those.
Okay, we need, okay,
We need four.
all right.
See, this is a whole.
Yeah.
Got a lot of objections, a few judgments down there. All right, and Mr. Member, I'm coming right back to you, sir. Do this one case. I know it's 5 after, maybe one other. Give that person just a little bit more time to come in and make a decision.
No worries, Your Honor. I appreciate it.
This is case number 19-150170. This is Credit Acceptance Corporations versus Deontay Carter. The matter is before the court on the following objections to a writ of garnishment. This matter, that judgment was entered on, just one moment here. On the 22nd of May, 2019, the judgment amount upon entry was $9,198.54. The objections to the writ of garnishment indicate, well, it does not check any of the boxes. Your appearance at this time for credit acceptance, please. For credit acceptance, your appearance. All right. And I have Deontay Carter on this matter, correct?
Yes.
Thank you, Mr. Carter. Mr. Carter, you have the judgment outstanding against you. That's why there's a writ of garnishment. You did not check off any of the boxes as to why you believe that you should not have issued. Talk to me, sir.
I'm sorry. When I was filling out the paperwork at 36th District, she didn't inform me that I was supposed to fill out anything extra other than the boxes she told me to fill in. I'm sorry. I didn't know I was supposed to fill out any area.
All right. Well, it's not her duty to inform you of anything about that. Just to inform, and then you work through it. That's okay. What is the basis for your objection? What are you bringing to me today?
At the time of this court date, I'm actually homeless. So yes, I do work, and I'm taking care of my family, my 2 kids, and garnishing my wages wouldn't help me be able to pay them. If we can come up to some type of agreement on me paying them monthly, that'll be fine if possible.
All right, sir. Well, the objection to the writ of garnishment is a real specific kind of thing, and based upon the things that you've indicated to me this morning, I don't see a reason that would be permitted by law to grant your objections to the writ of garnishment. So I'll find that your objections are invalid. It sounds like to me that you are asking the court to voluntarily, and get relief from the garnishment in that way. So let me consider that. So, has your check been hit with a garnishment yet, or it's just have they taken some money out yet?
I haven't noticed anything being taken yet. I haven't noticed anything being taken yet. No.
So what's going to happen is that at some point it should have happened already. I'm surprised it hasn't. They will take 25% of what you bring home. So how much do you usually bring as a check a week?
$700.
That's every week or every 2 weeks?
No, that's every week. I don't see the whole 700 because child support also gets money as well. They get $45 every week, if I'm not mistaken. I believe that's what it's called.
Okay, got you. So when you actually walk out of there with a check in hand, it's more like $650 is what you're saying?
Yes, pretty much. Yes, sir.
How much you said you're homeless, but how much are you paying to live somewhere? What are you paying?
I'm paying my sister. I'm giving her. Honestly, she hasn't asked for anything coming. So if I give her, I'll most likely give her 200 on my next paycheck. Honestly.
All right. So what about
my girlfriend is staying with me and my 2 children. I have a 4-year-old and a 1-year-old. Yes, sir. Yes, sir.
working?
Yes, sir.
All right. You got a car?
Yes, sir.
Are you paying the car note? That's what I'm getting at.
Yes, sir. Yes,
How
sir.
much?
That car note is $590 every month.
Okay, that's where your money's going, and then you got some insurance or something.
Yes, sir.
All right. So here's your challenge. If I allow that garnishment to stay in place, your the garnishment would take about $225 a week from you. So that'd be $900 a month. Yeah, that's obviously a hardship, but the law would allow them to take that much from you. How much can you pay on this? I mean, it's the ideal here is that you got a judgment that's a significant amount. It's I think it's ballooned to somewhere north of $11,000 now. So how much can you afford to pay on this a month? Now consider that in terms of whether or not to relieve you from the garnishment. Otherwise, I have to leave the garnishment in place. Garnishment will hit you. You already know that garnishment will hit you about $900 a month, and I don't want that to be the case. I think you find a way around it. So talk to me.
Okay. I get paid every single week. If we could possibly work out $75 every paycheck.
Yeah. I mean, that's definitely not a bad amount. That would put you at 300. Mr. Russo, you are not on this file, correct, sir?
Judge, unless on the rest of your actions, my office is, but I don't have any notice of this hearing.
Got it, sir. All right, thank you, sir. But sometimes he represents credit acceptance. That's why I was asking him.
No, that's fine. Just I happen to know as an attorney for credit acceptance, they use not only my firm but 2 others, even though I'm trying to say that they shouldn't. So have to stand mute.
All right, thank you, sir. All right, so the number that you are suggesting is actually not a bad number. I want to make sure that you can actually stay on the payment plan. So
okay.
What I'm going to do is I'll go ahead and set it at $250 a month, and that way you won't have the wage garnishment. It's a little lower than what you have suggested, but maybe it's manageable. It's going to be very important that you make the payment, because you don't make the payment, you end up with the garnishment, which will be the $900 a month. Okay, so I'll set the payment at $250. I'll suspend the garnishment in light of the agreement to make payments. The payment, your first payment at $250 will be due Just one moment, sir. On July 7th. So 7/23 will be you make your payment. You're gonna send that payment to the Lord and Lloyd, Lord and McDaniel's law firm that's listed on the document that you. So you'll be making the payment directly to them. They won't be taking it out of your check because I'm suspending the garnishment. You'll send the payment to them. You're going to order from me. That order that you're going to get from me is going to suspend the garnishment. I'm going to take that to your payroll so they can stop garnishing your check. And on the 7th of July, you have to voluntarily make that payment to the address where I mentioned. You will call them. You can call their office and find out if they have an electronic way for you to pay. In other words, you got to pick that part up. Make sure you get that payment in so that it doesn't revert back to the garnishment. Understand?
Understand.
All right. So you'll get some paperwork from me in the next day or so, sir. But I wish you well.
Thank you, sir.
And we're back on the record regarding the suffix 9115 Genesis Credit Union versus Tevin McKelvey. And that individual has not appeared. Counsel for Genesis has appeared. Go ahead and enter your appearance once again from the sir.
Your Honor, Michael T. Mamet, PA 1102 on behalf of plaintiff.
All right, thank you, counsel. Counsel, you brought to my attention on the record previously that satisfaction of judgment has been filed in this matter, release of a state garnishment that your office is satisfied regarding this matter. You've asked that the court would find that the objections are invalid, but that the question is now moot in light of the fact that the judgment is satisfied. Correct, sir?
That's correct, Your Honor. And has Miss Hunter received those documents via email yet?
She's a mess with a bunch of other stuff.
Sorry, no worries.
Yeah, let me see, 120 Campbell.
Campbell?
Is that for Campbell?
No, for McKinney.
No, I have not seen it.
She hadn't seen it yet. Genesis?
No, not yet.
Not yet. So.
All right. It should be coming through. I emailed my paralegal and two other people in my firm at 9:59 with her email. So hopefully it'll be coming through.
All right. And so the court is signing an order consistent with the determination made in this matter. The question is now moved in light of the fact that the judgment has been satisfied. So ordered.
All right. Excellent. Thank you, Your Honor.
Thank you. Good day to you.
You as well. Have a great day.
Other person is trying to come in. I'm calling you back, sir. I just want to make sure. no idea where that person went. All right, this is, case number versus Lehman Bench. The matter is before the court on the calling of objections to a writ of garnishment. This relates to the entry of a judgment in this matter, and the effort to execute thereon. Looks like the judgment was entered some time ago and was renewed within the time permitted by law. Counsel, your appearance at this time.
Judge, may I please court, I am Attorney Richard Rusin. I'm the attorney of record, my bar number 35222. Today, I'm also the respondent to defendant's objection to a income tax garnishment.
All right, thank you, counsel. And the objection that is set forth here says the funds or property are exempt, protected by garnishment from law, by law, protected from garnishment by law. I don't see Lehman Bench or any person on the Zoom. There was someone in the waiting room. I admitted that person that was not under the name Lehman Bench, but that person has not populated into the court. Counsel, what can you tell me about this, if anything?
Well, Judge, I can only go on not only the register of action from the court, but I also keep, for lack of a better word, my own office register of actions electronically. I see that there is a small remaining judgment balance remaining in the amount of $136.62. Now that figure I just quoted on the record, sure, from the Michigan Treasury Department that brought this case to your docket. I've applied that income tax disclosure, and I still show a very small remaining balance of $136.62. I see I'm actively garnishing an employer. Why I'm making a detailed record, Judge, is that there's going to be one of two things. That if you deny the objection today because the defendant failed to appear to prosecute the objection, then once I'm in receipt of a final $136.62 of payments from the employer, I will then have the judgment paid in whole. I will then file a satisfaction of judgment with the court. Alternatively, if I don't receive any other payments on judgment by garnishment within the next 90 days, I will probably end up still filing a satisfaction of judgment because of the very small balance legally due that is just de minimis. So that is what I'm telling you today to perfect the record, and on that I rest.
Thank you, counsel, and thank you for offering that information. How close this is, especially with this being a file that goes back to 2011 or so. Yeah, I think the only thing that I can determine today, of course, is that the objections are invalid, and I would release the funds withheld to the plaintiff, and that would close out this aspect of it. And of course,
yeah.
That would allow the plaintiff to take appropriate steps from this point. Right. So ordered. I'm signing the order consistent with the subject.
Thank you, Judge. On that I rest, and that's my last hearing with you.
All right. Thank you. Thank you, counsel. Good day to you.
Bye-bye.
That last case I have, I don't see the parties on that at all. That's that Lynn versus City of Detroit.
See it again.
Except for motion.
Oh, the guy's motion, he withdrawn his counsel. That's why.
Oh.
That's that one that you said for, you
Yeah.
wanted to talk to, he wanted to draw his counsel for them.
Oh, yeah, right. I did see that.
I sent the notice to them, but.
Yeah. So let's just renotice it for, to the city attorney
Mhm.
that's on the file. Just set another date.
Okay,
Try to do some figure out what it is.
okay.
Well, looking at Mr. Beach coming, so let's see. Mr. Beach,
Good morning, Your Honor. How are you today?
I'm good. I'm going to enable your video now. You know, we've been having a few problems, so that's why you're a little bit locked out there. All right. So what case are you on, sir?
Yeah, Your Honor, I apologize. We got delayed. We had another hearing in 36. We had one person covering a 9:30 and a 10, and that other hearing ran long. So I'm covering this hearing on short notice. I'm in credit acceptance versus Deontay Carter, Your Honor. 19.
Oh, yeah.
Yep.
I called that one, and Mr. Carter was here, and I dealt with that case. Let me tell you what happened on it. I waited, but Mr. Carter, of course, he really didn't have a basis for any objection on that matter. He didn't even mark off an objection on the objection board. And so I found the objections invalid. He asked the court for a payment plan. That was really his goal, was to get on some type of payment plan. And so,
Okay.
And so ultimately, after finding out what his wages were and what his likely garnished amount would be, as well as his family expenses and so on and so forth, then the court made some decisions. And by the way, as I go on the record with this, it's suffix 0170, Credit Acceptance Corporation versus Deontay Carter. Counsel, go ahead and put your appearance on the record.
Thank you, Your Honor. Michael Beach, BEACH P45459 for the plaintiff.
All right, thank you, Counselor. As I mentioned, I called this earlier and spoke with Mr. Carter. Didn't find a basis for his objections on the writ of garnishment. He said that he was homeless, living with his sister, and that his life was going to get worse with the garnishment. I said, well, it's not a legal basis for the objection to garnishment. He said, well, what I want is I can pay something, but I can't pay the garnished amount, so on and so forth. I calculated his numbers, looked like his garnishment might have ended up as high as maybe $900 a month if he got garnished. He offered to pay an amount. Ultimately, the court set his monthly payment at $250 a month. And I commenced that payment on the 7th of July, $250 a month on the 7th of July. I told him that the garnishment would be suspended with him being required to make those payments. I told him that those payments are to be sent to the office there in on Van Dyke and Warren. I also told him to contact the office, see if there is an electronic way that he can make payment on the account. I told him to reach out to your office in that regard. That's what happened on the matter. And those.
Well, Your Honor, I want to thank you, because if I had been there, that's probably what I would have done. So you did exactly what I would have happened anyways if I were there. I appreciate that.
I thought it was a reasonable way to deal with it, and because the defendant expressed a willingness to find a way to try to attack it, I said, well, let's see if we can do something. And that's what we came to. So.
Okay, I appreciate it.
All right, and you'll get a copy of the orders preparing right now regarding what happened.
Okay, thank you, Judge. You have a great day.
I see you, sir.
So Judge, you just given Lent a new date?
Yes.
Okay.